Let's see what happens when a deed of trust is in default. Actually, what happens is the lender has two choices. The first choice that a lender can take is to foreclose it judicially, go through a judicial foreclosure, and that would be the same as a mortgage foreclosure. So we don't want to talk about that right now. What we want to talk about is the second option, which is the non-judicial foreclosure, sometimes called the trustee's sale or the trustee's power of sale. And the first step, in order to get this foreclosure going, is for the lender, the beneficiary, to instruct the trustee to begin the foreclosure. Once the trustee receives that written instruction, the trustee then must record a notice of default and trustee sale. That's an official document that names the date, time, and place of the trustee sale. Very shortly thereafter, the trustee must send this notice, a copy of this notice, to the trustor, to the borrower. That's typically done certified mail. Important to note here that there's no acceleration of the debt. What does that mean? That means that instead of having to pay the whole thing off in order to stop the foreclosure, the borrower, the trustor, simply has to bring the payments current plus pay foreclosure costs and any penalties in order to reinstate themselves in the property and terminate the foreclosure. How long do they have to do that? Well, by law, they have a minimum of 90 days within which to reinstate. It could be longer than that, but they have to be given at least 90 days, and that right is called the right of reinstatement. Now, after that 90 days, and as early as the 91st day, the trustee may conduct the sale. That is a public auction where the property would be sold at public auction to the highest bidder. Typically takes place on the steps of the county courthouse. Now, when that sale is concluded, the high bidder, the successful bidder at the sale, receives what's called a trustee's deed. Now, if no one else bids, the lender typically would bid in the amount that they were owed, and the lender would get the deed. If someone bids over and above what the lender wants, that bidder would get the trustee's deed and own the property. What's significant about that is that means that there's no redemption whatsoever for the borrower after the sale is completed. So the borrower does not have any right of redemption after the trustee's sale. This is Jim Hogan. Thanks for listening, and please remember to subscribe to our channel.